Get ready for the dictation. On the count of 3, 2, 1, start. Since the petitioner was not a director of the company on the date regulations were framed by SEBI, he cannot be held liable for violation of those regulations and the directions issued to SEBI by Ms. Fair Deals Forest Limited. This is not the case of the respondent that the petitioner was manager, secretary or a person in accordance with whose directions or instructions the board of directors of the company was accustomed to act. He is not stated to be one of the persons falling in any of the categories mentioned in Section 5 of Companies Act at the time offence under SEBI Act was committed by the company. Therefore, he could not have been a person in charge of business of the company on the date the offence was committed. There is no allegation that the regulations framed by SEBI were violated or the direction issued by it was ignored by the company with the consent or connivance of the petitioner, or it was otherwise attributable to any act on the part of the petitioner. Therefore, he has not covered even by subsection 2 of section 27 of SEBI Act. It was contended by the petitioner in that case that he was only a sleeping director of the company and had already resigned from the directorship when the instrument was executed. It was observed by this court that resignation of the petitioner from the company was a defence which he could take before the trial court, and summoning order could not be quashed on the ground that the petitioner had resigned. There is nothing in the judgment to indicate that certified copy of Form 32 was filed before the court by the petitioner in that case. On the other hand, in the present case, the petitioner has placed on record the certified copy of Form 32, authenticity of which has not been disputed by the respondent. Though, as a general proposition of law, the defence available to the accused is not to be examined at this stage, there can be no valid objection to considering an authentic public document such as certified copy of Form 32 issued by Registrar of Companies in a petition under Section 482 of the Code of Criminal Procedure when the genuineness of the documents is not disputed and the matter can be finally disposed of on the basis of such a documents. Honorable Supreme Court observed as under. It is one thing to say that the court at this juncture would not consider the defence of the accused, but it is another thing to say that for exercising the inherent jurisdiction of this court, it is impermissible also to look to the admitted documents. It is one thing to say that a case has been made out for trial and as such the criminal proceedings should not be quashed, but it is another thing to say that a person should undergo a criminal trial despite the fact that no case has been made out at all. If charges are framed in accordance with Section 240 crore PC on a finding that a prima facie case has been made out as has been done in the instant case, the person arraigned may, if he feels aggrieved, invoke the revisional jurisdiction of the High Court or the Sessions Judge to contend that the charge sheet submitted under Section 173 CRPC and documents sent with it did not disclose any ground to presume that he had committed any offence for which he is charged, and the revisional court, if so satisfied, can quash the charges framed against him.